refused to enforce, to make concrete those aspirations that let them down, and I think the nation. So that's my interpretation of the history. And again, I want to be clear. I don't know how things would have played out had the courts been more vigilant about enforcing what I consider to be the true purpose of the 14th Amendment. But I sure think it would have worked out better for those folks in the South. Now, a couple sort of technical points that are actually kind of important. The Supreme Court didn't actually issue a ruling in McDonald. You had, other than in a result, basically the result was that Chicago's gun laws were declared to be unconstitutional under the 14th Amendment. But you only had a four-justice plurality for the idea that that right was protected under the 14th Amendment substantive due process doctrine. Justice Thomas, writing on his own in a concurrence, refused to sign on to that part of the decision and said, no, this is a privileges or immunities issue. That actually turns out to be really important for a host of reasons I don't have time to get into. But it turns out to be incredibly, incredibly important. And so we don't have a ruling of the court on the specific provision of the 14th Amendment that protects the right to keep and bear arms. And I think we have to stay tuned. I think Thomas, and apparently Professor Askin and I both agree, Thomas got it exactly right. He was absolutely right that the privileges or immunities clause protects the right to keep and bear arms. And I am certainly not going to be the one to stand up and defend Justice Scalia or the other justices in the plurality for going with substantive due process, which was absolutely wrong. I mean, this is a doctrine that Justice Scalia has practically made a career out of disparaging. And then suddenly a right comes along that he happens to like, and suddenly he's hugging it on the back seat. You're like, oh my God, Justice Scalia, you're hugging with substantive due process doctrine. What are you doing? So I'm not here to defend that. That was thoroughly intellectually dishonest, in my opinion. But for a variety of reasons, I think the plurality did not want to open the door to more liberty, which they think would have happened had they embraced privileges or immunities consistent with the text, history, and purpose of the 14th Amendment. I do not honor them for that choice.
Well, thank you very much to both participants. And now until about 35 minutes or whenever Professor Askin needs to leave, Vice President Jason Lamarco will moderate the question and answer periods. Please be respectful and brief in your questions, and please limit yourself to one question per turn. Thank you very much.
When you ask your question, just make it clear who you're directing it towards. Okay. Just want to start. Yes.
Yes. I'm wondering if each of you can comment on how you see the right to bear arms in relation to rights of privacy.
I couldn't hear the question. She asked, how do you see the right to bear arms in relationship to the right to privacy?
Again, I can accept it as a right, as a privilege and immunity of citizenship, a right of privacy in the home. So there's some vague relationship there. The right of privacy has so many different elements to it. It's hard. There's a right of informational privacy in some regards. There's a right of individual autonomy is sometimes a right of privacy. This would be a question of autonomy, not informational privacy. And I could accept a limited right to bear a home, to have a gun in the home as a right of privacy. This is, for example, in Neily versus Georgia, the U.S. Supreme Court said there was a right of privacy to have pornography in the home. Even though it could otherwise be banned, but you could have it in the home as a right of privacy. So there's some relationship there.
It's interesting to talk about the right of privacy. I love it myself, but I think it's a deeply incoherent doctrine as the Supreme Court has sort of addressed it. Because they just sort of seem to have this sort of pick and choose, or what I would call almost like a cafeteria constitutionalism, when it just sort of seems to depend on whether they like or whether they personally support the right to be let alone in a particular setting. So in trying to bring a more consistent approach to it, what I tend to think of it as is more like, I kind of conceive of the right of privacy to be left alone by the government unless they have a pretty good reason to be up in your stuff. And whether your stuff is like hanging out with a person of the same sex and doing some stuff, or smoking some stuff, or whatever it might be, they ought to have a pretty good reason for telling you that you can't do that thing. And I would just include in that the ability to own a gun. If you're an irresponsible, crazy person, I think that's a pretty good reason for being in your business when it comes to owning a gun. But if not, be giving some pretty good reason why you personally shouldn't be able to exercise this right, then I think they need to leave you alone. That's my conception of a consistent approach to the so-called right of privacy. Yes?
Mr. Neily, thank you for coming to Rutgers. I have a question regarding a comment about states' rights. You know, the lesson that we learned after the Reconstruction, you know, that it wasn't as much of a good thing as we thought it was. But after the 14th Amendment and taking into consideration advocacy for the incorporation doctrine, wouldn't and the fact that that would include the 9th Amendment, which makes other rights, you know, if you wanted to use it, other rights accessible, wouldn't that make that whole idea that states' rights, you know, was a dangerous thing no longer as dangerous if all other powers are enumerated to the federal government, or all enumerated powers are within the federal government, but everything else is left to the state? Wouldn't that sufficiently restrict state tyranny?
Yeah, maybe. Let me make sure I understand the question. So basically, maybe there's sort of a kernel of a good idea there in this idea of states' rights, if that's where we're going. Yeah, so what I would say is this. Again, I really push back against the concept of states' rights. Political entities don't have rights. People, individuals have rights. It's come to be kind of, you know, shorthand, but states have powers. And the question basically is, what is the constitutional allocation of powers as between the state and federal governments? And to illustrate that, I'll throw out what I think is maybe one of the worst, most unprincipled Supreme Court decisions in the last 20 or 30 years. Certainly on my short list, and that's the Raich case. That's the medical marijuana case out of California. There is nothing in the text of the Constitution that gives the federal government the power to put you in prison for growing a plant in your backyard and giving some of it to somebody who lives next door. No, those aren't the exact facts of Raich, but it's close enough. That's just that it's neither commerce and it's not interstate either. It's just none of their business. So what I would say is that's a great example of a setting in which I would argue that the states have the authority, and the federal government should not be able to impinge on it to decide if they want to make marijuana legal or illegal. So you might describe that as a state's right. I would just say that's a state prerogative or a state authority to do. What states don't have the prerogative to do or the authority to do is violate individual rights in the pursuit of, you know, public policy. So if Louisiana, for example, wanted to see if it worked out better if they allowed their cops to beat, you know, confessions out of suspects, somebody might come along and say, well, you know, that should be their prerogative as under states' rights. That I disagree with. That's not something they get to do. But so basically, within the states, I guess is what I would say, the things that are legitimately given to the federal government, and the federal government or federal law is, you know, supreme or controls, and the sort of individual's rights. Those are the two spaces that the states get to operate in between. And I would say deciding whether or not to make marijuana legal would be a great example of something that, in my view, falls within that space. I mean, you might even be able to make a case that I think you actually could make a right. That's actually an individual right. I think you have a right to put stuff in your body unless there's a pretty strong showing that it's really problematic. Based on the people I've hung out with this month, it's not really problematic. Anyway, so that answers your question.
Thank you. That was another bad Scalia decision.
Amen, brother.
Do you have anything you'd like to add to that?
Only briefly, I don't particularly disagree with that answer, but the states do have a basic police power. And when you're dealing with guns, dangerous weapons, the states do have an interest. And I think this is what I quoted Justice Stevens about why probably most of this stuff should be left to the states in their own wisdom, how to regulate the use of firearms. And while the limit I would go to as a right under the federal Constitution would be this right to own a gun in the home for self-protection. And anything beyond that, I think belongs to the state police power to regulate, and each state and the local entity will figure what's best for their citizens.
Professor Gonzalez?
Yeah, since you bring up Raich and you don't like the opinion, I wonder if I could just ask you to comment on Scalia's reasoning in Raich suggesting that under the Commerce Clause, Congress can reach even things that in isolation might be considered purely local activity, as long as it's part of a large overarching regulatory structure, and that regulatory enterprise would be undermined if Congress were not allowed to reach, in addition to the interstate features of the activity, also the purely local. And I guess I ask that because even Scalia is willing to endorse this, so it can't be all bad, right?
No, it could be all bad. Here's what I would say. When you're doing constitutional law, as a court, you can kind of almost always say, well, this case isn't that much of an extension from the last case. It's just an incremental step in this direction. But the problem is, when you're approaching a cliff, even if you take little steps, you'll eventually walk off the end of that cliff. And I think Justice Scalia's concurrence in Raich, for me, represents that point, because once you say that, now you're essentially saying to the government, the federal government, okay, between us, you weren't really supposed to be doing that, but if you enact a comprehensive enough scheme, then you can be doing it. And there's no logical stopping point, at least that I can see, for that. How about a federal national scheme of how much sex you can have, and then every time you have sex with somebody who will give it to you for free, well, that's sex you didn't buy on the sex market, and so we get to regulate that, There is a sex market, some places. So that kind of reasoning, just to me, it has no limiting principle, and really, you don't have a federal government of genuinely enumerated and limited powers anymore. And so I think that's just a step too far. I think he walked it off the edge of the cliff.
Can I just
sure.
back a follow-up?
Yep.
I guess one of the reasons I'm curious about your thoughts on it is that, today we have the District Court opinion out of Florida on the Health Care Act, and I guess, maybe I would put it this way. If, given the fact that we have one of the most conservative Supreme Courts in our history, justices like Scalia and, whatnot, and even Scalia is not really willing to, in any way, endorse a significant cutback on Commerce Clause power, what is the ultimate end game of the conservative constitutionalist vision of limited congressional powers? I mean, if you can't even do it, you can't even get folks like Scalia, and we'll see what Roberts and Alito have to say pretty shortly about the health care law. But if someone like Scalia is not even willing to go very far, then what's the point? Can the conservative constitutionalist project of limiting enumerated legislative powers really work out?
No, it can't, because they're not serious about it. Most conservatives that I run into as a practicing litigator are not. They're statists. They're not fans of liberty or genuinely restrained government. They're in love with majoritarianism and minimalism, and that's really their shtick, at least most of them. So the idea that they're genuinely committed to enforcing genuine constitutional limits on government power, I think is certainly not consistent with my experience of those people. So what I run into as a libertarian litigator is essentially status on the left and status on the right, mostly, in the sense that minimalism is now ascendant, I would say, on both ends of the political spectrum, and basically both liberal judges that I run into as a litigator and conservative judges essentially seem to have a view that other than the small handful of rights I personally happen to care about or think are constitutionally protected, the government should get to do anything else that it wants to. So I'm not looking to either side of the political spectrum to change that anytime soon. I agree with that. Do you have anything to add? All right. Who's a question? Eugene?
I have a question for Professor Askin. Professor, you indicated, I think you indicated your doubt that the original framers intended for the Second Amendment to be a limit on government's tyranny. You indicated your doubt about it. And my question to you is, given that the countries with the most restrictive gun ownership rights are like Cuba and the former Soviet Union, and the most permissive was mentioned, the state of Vermont, isn't that indicative both in terms of maybe history and substance that this might be a very important right in terms of limiting government tyranny?
I'm sorry, even though I have my hearing aids in, I'm not hearing your question very well. Maybe you can repeat.
I can repeat, Professor. Basically, given the countries with tyranny like Cuba and the former Soviet Union are the countries with most restrictive gun ownership rights, don't you